Muy buenas tardes.
Good afternoon to one and all. We will now beginning our 2087th meeting of the Committee Against Torture. It is a pleasure for me to welcome anew the delegation of the Republic of Azerbaijan. It is thus that we will be able to continue our dialogue. We began this dialogue yesterday. Without further ado, I would like to give the floor to His Excellency, Mr. Samir Sharipov. He's the head of delegation. He's also the Deputy Minister of Foreign Affairs. Sir, the floor is yours, please.
Dear Mr. Chair, distinguished members of the committee, yesterday we had a fruitful dialogue during which a number of issues was raised by the committee members, and due to the time restraints my delegation was able to address part of the questions raised, and today is ready to provide committee members with the further updated and detailed information. Let me now, without taking much more time, to give the floor to the members of our delegation. And now, first, I wanted to ask to take the floor Mr. Fazil Guliyev, Deputy Minister of Internal Affairs, to address the issues raised yesterday by Mr. Todd Backwell and Lee Huawen on the issues of access to justice and lawyers, application of the rights of detained persons, the right to be informed about the detention and arrest, the rights of defenders and journalists, human trafficking, increasing the professional training of personnel, and issues related to the juvenile justice. Please, Mr. Guliyev, you have the floor.
Thank you. Chair, distinguished committee members, work to ensure the full realization of recommendations from the Committee Against Torture are part of the everyday practical activity in our country and are part of a special plan. This is something that enjoys constant oversight. According to our national legislation, the police officers are obliged immediately upon taking someone into custody to inform them of their rights and to allow them to inform a loved one of their situation. Given that many citizens might be in custody, they might not be aware of their rights, and we have therefore set up special telephone devices for them to communicate with their family or other persons, and there is also a hotline to the Ombudsman and the Azerbaijani Committee Against Torture. There is also information on rights and freedoms of persons deprived of liberty available in Azerbaijani, Russian and English to ensure that persons in police custody or detained are able to become more familiar with their rights. They are given booklets that indicate their rights. Where necessary, the content of the booklets can be explained orally. According to the rules for detailed documentation of detention by the police, there is an electronic form, a single version, which sets out all of the information on temporary detention, including the medical examination, informing relatives, meeting with counsel, legitimate representatives, etc. All of our police, all of these facilities have the appropriate modern equipment, and there is oversight over the behavior of officers to ensure the upholding of the right to meet with a defense counsel and to ensure that this is confidential. According to a decision of the Ministry of Internal Affairs from October last year, at places of temporary detention, at police stations, there is a special room set apart where there are all the necessary conditions for such meetings to take place. In addition, there are no limitations in terms of time or the number of meetings between the defendant and their counsel or their relatives. Their rights are upheld, and if there are violations, these are immediately held to account. We are particularly attentive to the need to provide medical assistance to those in custody. They are given an immediate examination the moment they are taken into police custody. They are given a special medical card which sets out all of the information about their status of health and also any bodily harm, if there has been harm, and also the reason that it happened. If persons who have been arrested or in custody are ill or they received bodily harm during their time in custody, then there is a medical examination, following which there is a written communication to the lawyer. Where necessary, the person in custody is given medical attention. They have the independent choice of which medical facility to go to and the specialist who will carry out the examination. To expand upon the rights of arrestees and to ensure free choice of a medical institution or specialist, we are currently considering a draft law which overhauls the procedure for this, taking into account that the period of custody is quite short. Providing medical specialists for all of the persons in custody is not possible. Therefore, the medical examination is carried out by an invited doctor from a medical institution. To ensure oversight over the state of affairs in places of temporary custody, to ensure that the rights of persons in custody are upheld, to ensure rapid response, and to ensure that complaints are dealt with, especially those relating to cases of torture or other unlawful acts. We ensure that there are investigations by the Ministry of Internal Affairs. If we receive information, then disciplinary or other punitive measures may be taken in accordance with the law. If there is a report of allegations of torture or cruel or degrading treatment or suspicions that bodily harm may be occasioned by such treatment, then information about this is immediately sent to the prosecutor. In order to oversee the conditions of detention and to identify any possible complaints, we have set up the necessary conditions for direct and unrestricted monitoring in places of temporary custody by monitors from government and non-government organizations. In this way, in 2022 to 2023, we carried out there were 358 such monitoring visits. Certain steps are being taken to address these. Regarding juveniles, their physiological and psychological capabilities must be taken into account. According to our legislation, interrogation of minors must take place with their representative present. There are also pedagogical experts and doctors who are present, and there is a lawyer present if there has been a charge and the juvenile may not refuse this. Children can only be detained in the case of particularly severe crimes. Our legislation prohibits keeping a child in custody together with adults. This is only possible when it is in line with the child's interests. I would also like to note that to effectively resolve police tasks and to ensure the constitutional rights of individuals are upheld, in 2022 to 2023, there were multiple training courses and online events, seminars organized in our country and abroad to discuss various related topics, and there were several thousand participants in Azerbaijan. There was professional training dealing with human rights. At the end of each academic year, the Special Commission verifies the knowledge gained by students, and they are given certification. In addition, we have significantly expanded the programs available at the Police Academy. Regarding criminal procedure and criminology, there are several lessons, seminars, and practical courses on how to carry out interrogations. The academic program for this year provides as well for topics that are included in the European methodological recommendations on interrogations and how to ensure that they are effective. We are considering the procedure for relating to suspects among the junior officers because this category of staff are not typically present at places of custody. According to the Convention Against Torture, we discussed its provisions in a workshop in October 2023, and we are taking steps to enhance its more effective implementation. Regarding cases of suicide in places of temporary detention, from 2020 to 2023, we registered 7 such cases. For each of them, there was a verification to highlight the facts, and then disciplinary measures were taken for improper oversight over the inmate. One person was dismissed and other persons were subject to disciplinary measures. We pay particular attention to important areas of action, such as combating trafficking in persons. In 2020, we adopted our 4th National Plan of Action to combat trafficking in persons in Azerbaijan for 2020 to 2024. As a result of measures taken pursuant to this plan, over the last 4 years, we have identified 627 acts of trafficking in persons, and this also involved forced labor. There were 373 victims identified. 69 persons were prosecuted. Several of them have been convicted to various custodial sentences. According to a decree from the Cabinet of Ministers of September 2019, there is a mechanism which allows for the identification of victims. In the same period, we've provided assistance to more than 200 victims of trafficking in persons. We take all necessary measures to provide medical and psychological support, and we provide basic items for personal use where necessary. Several persons were provided with employment, several dozen more were provided with training. We also devote particular attention to child victims. More than 100 such children were provided with training, with educational material 43 were involved in a preschool program, 53 were given birth certificates, and 41 children were given support to establish who their parents were, and they were also provided with food. Thank you very much.
With your permission, Mr. Chair, I thank you, Mr. Guleev, for his presentation and contribution. And now I would like to give the floor to Mr. Cengiz Askerov, Deputy Chief of Supreme Court, to provide relevant information on the questions raised yesterday by Mr. Todd Backwell. And I would like to ask you to address the questions within the Article 125 of the Criminal Procedural Code, issue of expulsions carried out on the basis of diplomatic assurances, issue of reliance on confessions, court's approach to allegations on torture, as well as cases related to Toplum TV, Abzas Media, and Söğütlü. At the same time, I would like to ask you, Mr. Askerov, to reply on the question raised by Mr. Erdogan Işcan related to domestic remedies. You have the floor, Mr. Askerov, please.
Thank you, sir. Distinguished Mr. Chairman, distinguished members of the committee. I'd like to start with the short answers to questions and then turn back to the practice of the national courts of the Republic of Azerbaijan. According to the constitution of the Republic of Azerbaijan, all international agreements adhered to by the Republic of Azerbaijan, including the international human rights instruments, have direct legal force on the whole territory of the state. And therefore, as you might be aware, the European Convention for the Protection of Human Rights and Fundamental Freedoms forms a part of our legislation, and the case law of the European Court of Human Rights also have direct force in the Republic of Azerbaijan and widely practicing by our courts. Firstly, I'd like to refer to the question of examination of diplomatic assurances while examining the question of expulsion of foreigners from the territory of Azerbaijan. According to the case law of the European Court of Human Rights, these diplomatic assurances have some importance, value for examination of such cases, but they don't have a decisive value. Therefore, in the practice of our courts, while there are diplomatic assurances, they don't have a decisive value, and they are being examined together with other circumstances of the case. If there are any considerations of security for the foreigner who is under the expulsion procedure, these diplomatic assurances might not be taken into account. Another question was concerning the reference to or examination by private doctors of the detainees. This question is also arising the practice of our domestic national courts and also the law enforcement agencies also is based on the practice of the European Court of Human Rights. And I can assure you that according to such practice, now where any detainee asks for examination by private doctor of his own choose, then this is ensured, and the private doctor has an access to detainee and provides forensic examination and gives a medical opinion concerning his or her state of health. These cases, a number of such cases were also submitted to the European Court of Human Rights, which they were taken into account. I'd like to draw your attention also to the decision of the Plenum of the Supreme Court of the Republic of Azerbaijan of 24 December 2021 concerning the judgment of the court in the criminal cases, which is also based on the case law of the European Court of Human Rights and addresses the whole range of matters which can arise in the criminal proceedings, from the arrest to the delivery of the final judgment. And several questions raised by members of the committee will also have answer in this decision of the plenum. For example, the Article 125 and the burden of proof. What are the proceedings when there are complaints or concerning or allegations concerning ill treatment at the pretrial stage? The practice of the national courts is based on the case law of the European Court of Human Rights, and I'd like to bring you an example of the approach of the European Court of Human Rights, which was expressed in its recent decision in the case of Ismailov versus Azerbaijan. It is of February 2024, where the lawyer alleged that he was ill-treated by the police, by the members of the police. And the court here, and I quote, said that it cannot be said that the applicant raised an arguable claim or made a credible assertion. In view of that conclusion, it cannot be said that the authorities were under an obligation to investigate further the applicant's allegations. So the approach of national courts is the same. An individual has to bring arguable claim, at least any evidence or concordant evidences that he was ill-treated, and then upon these claims, allegations, the court starts investigation, or on its own in the trial, or it refers this investigation to the prosecutor's office, then waiting for the response of the prosecutor's office on the results of the investigation. Concerning the reliance of the criminal proceedings on the confessions by the detainees, this question has been also addressed in the decision of the plenum of the Supreme Court, and it says that the court judgment can only be based on the evidence investigated directly during the trial. That means that any discrepancy in the statements by the accused or by witnesses given at the pretrial stage or during the trial should be investigated only during the trial and be examined together with other concordant or dissenting evidences. The complaints procedure, I told about it. It's being also here described. The question of domestic remedies of the victims of ill treatment, the courts, according to our legislation and also to the practice of the courts, any individual who has been established as a victim of ill treatment has a right to remedy his violated rights, and we not only the victim of ill treatment, but also those who were unlawfully arrested or who were arrested during the pretrial stage and then were acquitted by the court. They have the right to compensation. Besides, the criminal code establishes the responsibility of those who are responsible for ill treatment. Therefore, we have the cases. These complaints or claims are being examined within the civil proceedings, and we already have several cases or judgments when the victims of unlawful arrest they received financial compensation, or even the victims of ill treatment they also receive compensation for pecuniary or non-pecuniary damage. There were also questions concerning certain individuals of civil society members and social media journalists and their arrests. I can only say that these arrests are not connected or related in any event to their professional activities, and they were brought to criminal responsibilities for financial offenses, in particular the smuggling of money in large amounts. This is concerning the Abzas Media and Toplum. Concerning Gubade Badoglu, he was brought to criminal responsibility for financial fraud, and it was during the search in his place, it was found about 20,000 of false United States dollars, and therefore he was also brought to criminal responsibility. I also like to note that several persons, including those whose names were mentioned yesterday, they applied to the European Court of Human Rights with the request for application of interim measures under Rule 39 of the Rules of Court, alleging their poor health conditions, and to respond to the European Court's request, the authorities organized independent medical examination, forensic examination of the individuals, and submitted to the court all the medical documentation of these individuals, and the court rejected application of interim measures. And the day before yesterday, Gubade Badoglu was pretrial arrest was remitted to the house arrest. I think these are the questions which I should respond. Thank you very much.
I thank you, Deputy Chief of the Supreme Court, Mr. Rascara, for your valuable contribution to today's discussions. And I now wanted to turn to Madam Sadagat Gahramanova, Deputy Chair of the State Committee for Family, Women and Children Affairs, to address the issues related to the activities on combating domestic and gender-based violence and effective protection mechanism existing in the country, as well as the corporal punishment of children and training activity. You have the floor, Madam Gahramanova. Please.
Thank you. Distinguished Chair, distinguished committee members, distinguished participants. I greet you all. The Convention Against Torture and Other Cruel and Inhuman and Degrading Forms of Treatment means, first and foremost, the protection of human rights, the rights of men, women and children. Our law on gender guarantees for gender equality, ensures respect for human rights and gender mainstreaming in all areas of society and life. The Government Committee submits an annual report on implementation of the law, which allows us to carry out a gender analysis as a government entity and also within the private sector. In all local government authorities, there is a gender commission where there is monitoring among families, and formation of gender relations, identification of cases of domestic violence, and other behaviors that undermine human dignity. We have a law on domestic violence. According to a presidential decree, we have adopted a national plan of action to combat domestic violence from 2020 to 2023. In order to implement the measures in the national plan in all executive and government bodies, we have a gender group, and this deals with domestic violence and violence against children. These monitoring groups are in effect throughout the country. Anyone dealing with the police, the prosecution service, educational institutions, healthcare and social structures. Where cases of violence are identified, the perpetrators are punished according to the law. In addition to providing assistance to those who have suffered violence, since last year we have been working with those who perpetrated acts of violence. There is also rehabilitation of children who have suffered as part of the violence process. The rapporteur raised the role of law enforcement in gender equality and domestic violence. Under our policy for training, we trained 696 members of the Ministry of Internal Affairs. In addition, several police officers went through a training course on domestic and gender-based violence and risk assessment. Awareness-raising activities have been carried out in all educational institutions. There was a question about the hotlines. In 2020, we opened a hotline, 865, where we have had several complaints, more than 900 from women and 12 from men. There is also a children's hotline, 117 and 111. There was also mention of sexual violence. One of our priorities of government policy is labor rights. Women are part of the economic labor force, about 45%. Last year we carried out a study into sexual violence. We did not find any cases, but we are carrying out outreach and awareness raising in this regard. In order to promote development of economic rights and entrepreneurship among women, especially rural women, we have a technical assistance policy. Under this project, we have set up women's resource centers throughout our regions. These centers help to prevent domestic and gender-based violence by addressing economic issues which are encountered by women. Several hundred women were involved in training provided by the women's resource centers. More than 800 women also opened their own business. I would also like to inform you about our efforts to protect children's rights. To implement the plan of action for the children's strategy running to 2025, we have prepared a new draft law on the rights of children. This includes legal norms on corporal punishment against children. Also, in the Code of Azerbaijan on administrative violations, we've set down particular penalties for parents who use corporal punishment or for staff at schools, sports organizations, medical institutions, and other institutions which are responsible for caring for children. We have drawn up a draft law on minors. Both of these drafts are currently being considered by the government authorities. According to the law on the rights of the child, children have the right to physical integrity. Any natural or moral person responsible for caring for children can submit a request for improper treatment to cease. Subjecting children to violence may lead to the repealing of parental rights according to our law and also to criminal liability. In cooperation with the Ministry of Justice and the Penitentiary Service, we work systematically with children in care institutions. We educate them on a healthy lifestyle. We ensure meetings with children. There are lessons on rights of the child. There's also an open day and meetings with peers. Currently, about 500 women are serving sentences in our penitentiary institutions. Their family situation is constantly monitored by the Committee for Family, Women and Children Affairs. We work with all children's institutions, and children live close to the places of their mother's detention. We also deal with various social issues such as pension, disability payments, etc. Thank you.
I thank you, Madam Gahramanova, for your intervention. And now I wanted to give the floor to Mr. Ilgar Kasımov, Deputy Minister of Health, to address some issues raised yesterday by Madam Anna Raku. Please, you have the floor, sir.
Благодарю, уважаемый председатель.
Thank you, Chair. Distinguished committee members, ladies and gentlemen. At the outset, I would like to note that the Constitution of Azerbaijan and the law on protecting public health guarantee everyone equal access to healthcare and medical assistance irrespective of race, ethnicity, religion, language, sex, origin, property, or professional status, also political or other convictions. I would like to answer the question from Ms. Raku on Psychiatric Clinic number 1. I would like to note that this is a major psychiatric clinic. It has an extensive history going back many years. There is currently refurbishment going on at parts of the building that should be concluded this year. Now, regarding restraint measures, this was also mentioned. If there is a danger from the patient to themselves or to those around them, they might be briefly isolated. There is no mechanical means used for this. Currently, in Azerbaijan, as elsewhere in the world, we have high-quality therapy available. Regarding the lack of psychiatrists, and thank you for that question, this is a trend we see elsewhere in the world, including in developed countries. I don't want to take up extra time here, but I would like to note that there is professional burnout of psychiatrists. And this plays a role in the lack of psychiatrists around the world. The Ministry of Health works with universities to deal with this. We draw in students who show an interest in becoming psychiatrists. There are also various regional incentives, and we do hope to make some progress here. Our Ministry of Affairs works with the World Health Organization under the program on mental health. And we do hope that we will be able to address this situation That is the lack of psychiatrists. And to bring more into the polyclinic services. This is something done in many other countries. Also, following on from what our previous speaker said, Ms. Garahmanova, we have a children's psychological center which provides assistance to children suffering psychological and neurological diseases in order to ensure access to psychological services for children with disabilities, including those on the autism spectrum. The Ministry of Health works with local non-governmental organizations which are members of the Public Council. There is also a children's hotline, 116-111. This psychological center works with a partner in the US, and in 2020 it carried out a project to provide psychological support and to ensure psychosocial rehabilitation of children, including the return to their parents or to boarding schools. We have provided such services to about 400 families, and this will continue until 2025. We also have a Center for Public Health and Reform. This is active on social media to tackle stigmatization, discrimination, and barriers faced by persons with disabilities, with mental disorders. This is aimed at the public and at medical personnel. Also answering Ms. Raku's question, I would like to note that at our psychiatric clinics, every 3 months, medical personnel go through training on relations with the patient and other topics. Now, in the case of violations, here I should note that we have a law on rules and norms for ethical behavior of medical personnel in Azerbaijan, which is also governed by Decree 137 on ethical behavior of doctors and medical personnel. That is of 2011. All complaints of cruel treatment of persons, including children, at psychiatric institutions are dealt with promptly by the relevant department of the Ministry of Health. These clinics are subject, they report rather, to the Ministry of Health. Following these reports, persons who treat patients improperly are dismissed from their post. In Azerbaijan, under the state program to combat the illicit circulation of drugs and psychotropic substances and their precursors, and to combat drug addiction, this is something that we conduct a lot of work under. We have an outpatient rehabilitation unit, and we plan to set up similar divisions at medical institutions throughout our country. In addition, in cooperation with CSOs, we are working to expand alternative replacement therapies among users of injected substances. Currently, in Baku and Sumgayit, we have such centers in operation, and they are working very well. We do hope to build upon them. regarding tuberculosis. We have adopted a law on combating tuberculosis and also decisions, decrees and instructions from the Ministry of Health which create a legislative basis to combat tuberculosis. Also, as a result of measures taken in accordance with the strategy of the WHO to eradicate tuberculosis, the situation is now stable. But of course, we will need to work harder. We have set up specialized hospitals for diagnosis and treatment for forms of tuberculosis that tolerate treatment. That's another problem. We have a fully equipped laboratory network in 5 regions. And a national reference laboratory too. Following the setup of these laboratories, we are able to offer the best diagnosis through an express testing system for tuberculosis. All patients are given medications of the first and second rank for tuberculosis. There are programs of various duration, and also patients with tuberculosis are able to access treatment immediately. I should also note that this is free of charge. We have all of the necessary medications and we ensure monthly monitoring. Mainly the care is at outpatient centers. The patients are also given payments to cover for their temporary unemployment. Also, on the problem of HIV, we also have a government program in Azerbaijan. And here we follow recommendations from the WHO. According to the principle of treating all, we have successful experience in our country of prevention of mother-to-child transmission. Last year, we did not find a single case of mother-to-child transmission. We take active steps to meet the 95-95-95 call from WHO and UNAIDS. That is the percentage of those treated and reduction of persons with HIV that can be passed on, 95%. Also, for persons who suffer violence or any other forceful acts which raise the risk of HIV transmission, measures are taken for post-contact prevention. I would also like to note that in 2023, we received certification from the WHO as a country free of malaria. In conclusion, we have a multi-sectoral approach to implementing the convention, and this is the bedrock for greater effectiveness in our efforts. We thank the committee and other partners for their support in this humanitarian endeavor. Thank you.
Thank you, Mr. Deputy Minister, for your extensive information that you share with the members of the committee. And now I ask to take the floor by Mr. Kemal Galijev, Head of the Service Investigations Department of the General Prosecutor's Office, to address some points within your competences, and then followed by Mr. Vusal Aliyev, Chief Assistant to the Prosecutor General. to inform the audience on the training activity and to provide some statistical data. Mr. Galidzev, you have the floor, please.
Thank you, distinguished chair, distinguished committee members, colleagues. I would like to inform you that on the 14th of October 2023, the General Prosecutor of Azerbaijan and the Ministry of Internal Affairs signed a joint decree to ensure full protection of the rights of persons suspected of or charged with treatment and cruel treatment and torture, and also a plan to effectively combat this phenomenon. According to the decree, we have a CISO where detainees are held, and they may be transferred to a different place of custody only under exceptional circumstances. These include investigation that cannot be carried out at the CISO, experiments and others. All of these investigative actions which may take place at the CISO and also when persons are brought to the CISO cannot be carried out without oversight. Interrogations may only be carried out in the room for this purpose. We have taken the necessary measures to ensure that additional interrogation of suspects and accused of severe and very severe crimes took place with video recording, fully showing the room where the interrogation takes place, and the recording is from the start to the very end. There is also a record of the family names, those present, these interrogations in general should not be carried out by more than 2 persons. That no one else should be present in the room apart from those ensuring security. That the interrogation should take no longer than 2 hours without a break. The necessary measures should be adopted to ensure timely identification of acts of torture or cruel treatment by the suspects or the accused. Where the protocol for persons located at CISO or in temporary custody is broken, or the protocol is not followed, there are medical personnel employed at these institutions that must be informed. Following complaints of torture against an official, there is immediate provision to the prosecutor's office of each act identified by the prosecutor's office or the investigative bodies themselves, or by state bodies or international organizations, or published in the media. The relevant material is sent to the prosecutor's office for investigation and to ensure repetition investigation by acts of police officers. According to the decision of the Procurator General's office, where the rights of minors are broken by law enforcement officials, according to paragraph 32, we have set up a disciplinary commission under the Procurator General, which has a procedure for verifying the acts alleged and taking disciplinary measures. This sets out disciplinary measures this commission considers the material collected during the investigation, and then disciplinary measures may be taken according to the principles of fairness, impartiality, and objectivity. As a result, a report is submitted to the prosecutor's office. This is how the prosecutor's office decides on disciplinary measures, and it will make the appropriate decision. Now, on verification of information on acts of torture or cruel treatment, or violation of Article 27 of the law on torture, criminal investigations are opened. Currently, this information is verified only by this particular body for investigation, which answers only to the Procurator General. As I said, this is the only body competent for these investigations. And now I give the floor to our colleague, who is a senior assistant of the Procurator General's office. Please.
Thank you. I'd like to submit a few information regarding the data on cases in which, during the period under review, officials have been disciplined for failing to respect the rights of detainees. From 2020 to 2024, disciplinary proceedings were initiated against 102 prosecution employees for violating the rights of suspects and accused persons, for procrastination and for not properly performing their duties. Of these, 6 individuals were dismissed from their prosecution authorities, 66 employees were reprimanded, 18 were warned, and 12 were removed from their positions. Excluding the prosecution, internal investigations were ordered for 70 individuals from other law enforcement agencies due to violations committed. Additionally, I'd like to give some information regarding the CPT report. A number of cases mentioned in the report adopted at the 111th meeting of the Committee for the Prevention of Torture, Inhuman and Degrading Treatment or Punishment of the Council of Europe, held on July 2023, were reviewed. 2 criminal cases have been initiated pertaining to the mentioned facts under Article 309 of the Criminal Code, which addresses the issue of exceeding official powers, and 1 case has been remanded for further investigation after the decision was annulled. And also regarding the information on training programs in Prosecutor General's office, in recent years, the Science and Education Center of the Prosecutor General's office has conducted numerous educational and enlightening events for the employees of the prosecution and other law enforcement agencies. The trainings primarily focused on the following topics: consideration of modern international practices during the restriction of the right to freedom in the context of criminal prosecution, combating torture and other cruel, inhuman, or degrading treatment or punishment, adherence to legislation, human rights, and civil liberties during operational search activities, the principle of superior protection of children's rights during criminal prosecution, accessibility of women to justice, cases evaluated as gross violations of the right to defense during preliminary investigations, issues arising from international conventions on the elimination of all forms of racial discrimination, application of the principles on effective interviewing for investigations and information gathering based on Mendes principles during the interrogation of individuals. More than 1,300 employees of law enforcement agencies, as well as over 220 newly recruited employees of the prosecution, have participated in these trainings. Thank you.
I sincerely thank you, Mr. Galejev and Mr. Aliyev, for your replies to some of the questions raised yesterday and for your general contribution to today's meeting. And now I want to give the floor to Mr. Adil Abilev, Head of the International Cooperation Department of the Ministry of Justice, who will address some of the points raised by Mr. Todd Backwold and Anna Raku. He will address some issues related to Article 40 and 293 of the Criminal Court, particularly in the context of severity of the penalties, as well as Article 75 of the same code. He will also refer to the issues of expulsions on the basis of diplomatic assurances. That issue was, in some part, was addressed by the Cengiz Askerev. He will provide some additional information. He also will inform the audience about the issues relating to the Istanbul Protocol, conditions in penitentiary facilities, overcrowding of the prisons, medical staff matters, vocational activity, and children in conflict with law. Mr. Abilev, you have the floor to address all these extensive questions. Please.
Thank you very much, Mr. Sharifov, distinguished chairman, members of the committee, ladies and gentlemen. Mr. Sharifov has already outlined the points, the bullet points that I'm supposed to talk, and that was, as you've heard, very extensive one. But indeed, yesterday, a number of issues raised by the rapporteurs really do fell under the jurisdiction of the Minister of Justice. So I would like to start with Madame Raku's questions, and I will try to be brief. But yet we still have extensive information to submit. And indeed, as Madame Raku mentioned, Azerbaijan and Moldova, they share a common Soviet legacy. And we understand that these problems with the prison conditions shall be duly addressed. And that is actually on the governmental level, that there is a political will in Azerbaijan to reform the penitentiary. Actually, Azerbaijan was one of the first countries on the post-Soviet era who transferred prisons from the jurisdiction of the Ministry of Interior to the jurisdiction of the Ministry of Justice. And another problem that we faced was that actually the majority of prisons, the vast majority of the prisons, they were located in Baku, in the capital, and it was really difficult for the relatives from the regions to come and see their relatives and so on. So basically, one of the elements of the penitentiary reform was to build new prisons which meet best practices and European standards. The other one was to carry out this work not in the capital but also in the regions, so that the prisoners, they can serve their sentences close to their families, which would further obviously serve to their better social adaptation and reintegration back into the society. In this direction, the number of legislative, institutional, and practical actions have been taken. And when it comes to infrastructure, I would like to say that within the last 3 years, we built new prison for females. So the old prison, number 4, which was cited by Madame Raku, and it was also cited in one of the CPT reports, it ceased to exist, so it's no longer exists anymore. And also we built a new prison for juveniles. That was done both in 2022. In 2023 was built a prison which replaced Kobustan prison, which also reported having not really good conditions. Now we have a new prison, and I would like to specifically add that that prison was built with the recommendations of the CPT. We even asked members of the CPT when they were visiting Azerbaijan to visit this prison, maybe to provide some additional recommendations that we can use while the prison was still under construction, which was done by the members, and later on we used them. And the most modern achievement that Mr. Sharif also mentioned in his opening speech was the introduction of the new mixed regime penitentiary institution in Lankaran. This is the region in the south of Azerbaijan, close to the border with Iran. And it's also a brand new prison and the facility. And another tangible element, tangible example of the political will in this area is that President of our country, while visiting this region, he also specifically went to see the conditions created for prisoners. And it was broadcasted, of course, by TV media and spread with the photos and videos so that all the public in Azerbaijan, they are aware what are the conditions nowadays provided to prisoners. And another thing that Madame Raku mentioned was the problem with the Ganja pretrial detention facility. In this regard, I'd like also to mention that there is a construction of new also penitentiary institution, mixed one, which will absorb pretrial detention facility and the facility itself, so kind of prison, is under construction in Ganja. 47% of the construction has already been done, so basically, hopefully, with the proper funding, we can also finish the construction of it within the coming years. And regarding the 4 square meters that you mentioned, Madam Raku, as well. Of course, all these facilities, they provide minimum 4 square meters per person, excluding sanitary facilities. Then I would like to mention another issue that you raised. By the way, we also, along with building new prisons, we're also spending money on repairing of the old ones, including the Shuvalan pretrial detention that you mentioned also, which also located in Baku. Another issue that you mentioned is the staff member. If you look into the reports of the Council of Europe, there is a common problem with the staff members in many countries, including medical doctors, and we also understand this problem. And just for your information, since 2020, the staff number increased by 12% in the penitentiary, including 4% of female staff. And this year we asked also for extra staff, so hopefully we'll get more this year as well. Regarding the issue that was mentioned by the Subcommittee of Torture while they were visiting Nakhchivan, that you mentioned that there was only one female guard in there. Nowadays, it was easy to check because the facility is not so big and not so many prisoners currently are serving their sentences. So nowadays there are 8 female prison guards. But you also need to take into account there are only 6 female prisoners in there at the moment. Regarding the budget allocations, also, of course, it's a common problem. I mean, when you discuss the issue of allocating money with the Minister of Finance, obviously prisoners are not in the top spot. Yet, Minister of Justice, we are trying to work in this direction. And since 2020, the budget allocated to the penitentiary system and the amount of money allocated per person, per prisoner, both increased by 1.6 times. And also, we have a gradual increase in the quality of the medical assistance in prisons and pre-trial detention facilities. As Mr. Askarov mentioned earlier, when it is needed, we can invite medical doctors from civil sector. We can send the particular person outside to the civil sector hospital to carry out specific surgery, which is, for instance, not possible to be carried out inside the prison facility, or if a person wants a specific surgeon or doctor to carry out this operation. I would like to specifically mention the fighting TB in prisons, because I believe that we have some developments that are worth to be shared. And it's not our opinion, it's the opinion of the ICRC and the Global Fund, which we have been working for many, many years. We started to address this problem since 1995. And at that time, it was really a huge challenge for those who were sentenced, because, as you mentioned, the old barrack type prison, it's really provides a huge risk of TB to be spread drastically. According to the World Health Organization analysis, the risk of the TB to be spread inside the prisons is 100 times higher than in the civil sector. So we started to work with the ICRC, and just in kind of bullet points, I will try to highlight the developments, the achievements that we have at the moment. First of all, when a person arrives to a prison, we have a Gen Expert equipment, which helps to test a person in 100 minutes that whether a person is infected with TB or not. Then since 2009, we not only treat prisoners inside the prison, but also we follow up once they are released. But the medical treatment is not over. We still do the follow-up once they are free in the freedom. And we also cooperate in this area with various NGOs. Just to figure out the results that we reached, if the WHO sets the 90% threshold for the positive treatment of normal TB, we have 96%. When it comes to multi-resistant form of tuberculosis, it's the 85% according to the World Health Organization, whereas we have 88%. And just for you to compare, if you compare the number of deaths in prison since 1995 and 2023, the death rate went down by 169 times. 169 times. When you compare 2013 with 2023, it's 3 times less. And just for you, as an example, last year we had only 8 cases, 8 deaths out of the tuberculosis, but all of them, they were aggravated by the other diseases like HIV and hepatitis. Thanks to these results, positive results, World Health Organization since 2014 established the Collaborating Center for TB Control in Prisons in Baku, just very close aside to the special medical facilities for TB prisoners. And it's got international status. It was 2 times prolonged, last time in 2022, for extra 4 years. So what the center does, it provides training for TB control in prison system from different countries. Since its establishment, we had around 200 training activities, which were joined by 2,600 of participants from Africa, Asia, Europe, and even South America. Representatives of 21 states visited our TB facility and this center to study the best practices we've got, including representatives, not only the Minister of Justice, but also the Minister of Interior, Minister of Health, and representatives of the civil sector. And I would like to know that some of the countries, they are represented also here, like we have the visitors from Moldova, China, Turkey, and many others. Regarding the psychological care in psychiatric care in prison, it's really an issue, and it's not only, as our Deputy Minister of Health mentioned, that it's a common challenge, not only in prisons but also in the civil sector. We have very good assistance with the Council of Europe, with the European Union. We had a number of projects held together on training in this area. We had even Turkish psychiatric professors visiting Azerbaijan to do training of trainers. So we're also understanding the problem. We're working in this area as well. Regarding another issue on the alternative measures, as you rightly mentioned, we had a decree of the President dated 2017, which set up a number of actions and tasks to be done in terms of the reducing overcrowding and applying alternative sanctions. Since then, we had a probation service established in Azerbaijan. So the decree was dated 2017. In 2018, the probation service was established. We started best practices with different countries, even our neighbors and some others, to see how fast we can let this service grow. Because, to be honest, in some countries, the probation services were at first stage only allowed to minors. In some countries, it can only be done voluntarily. So the accused persons, they were kind of getting an option whether to go to prison for a less number of years, like let's say for a year, or 2 years in probation, and they were choosing prison instead. Just a couple of figures. Since the establishment of the probation service, we used around 20,000 bracelets. Because according to the change into the legislation, we had introduced a new sanction, limitation of liberty, and the bracelets, this electronic monitoring, is being used for this particular execution, for this particular punishment. Apart from that, the probation officers, they're dealing with community works, with the correction works, with fines and so on. So currently our probation service has under supervision a bit over than 24,000 persons. Apart from that, as an element of the humanization of the legislation in Azerbaijan, we had like 3 stages, 2017, 2018, and the last one, 2020. A number of, about like 35 crimes, they were decriminalized. Some crimes had their sanctions increased, so that that really affected the prison population in terms of reviewing their sentences and even releasing a number of people. And just for your information, due to these reforms, about 6,000 prisoners, they were released, they were covered, including 1,216 were released in 2020. Also, we are widely using release on parole. We never stopped doing that even during the COVID period, making benefit of the video conferencing equipment that are provided in all of our facilities, so that court proceedings can go on, and this very equipment helps us to do the interviews. We have a special commission on the parole, which also, among officers of the Ministry of Justice, they also include members of the NGO. And since 2020, about 11,000 prisoners they were released on parole. So within these 4 years. Amongst these other things, also, as Minister Sharifov mentioned, amnesties and pardon acts in Azerbaijan is a kind of widespread practice. We had 2,700 persons released from prisons following the amnesty, and 1,385 persons were pardoned. And also, just for your information, normally in May we have an Independence Day, the holiday in Azerbaijan, and normally at this stage we also are expecting a new pardon decree. Also, another issue that we recently started to introduce is the restorative justice, because in 2022 there was a conference of the European Ministers of Justice in Venice, which was devoted specifically to this very issue. So we started to work on this area, and we even became a member of the European Forum on the restorative justice, and we also work with the social services agency. I will not elaborate on this issue because we have a colleague in our delegation who will further on also speak about this very thing that we're doing. But also a couple of points that I would like to note that Madam Rako mentioned. Regarding the juveniles, we are now stopped the practice of using the solitary confinement in the juvenile facility. It was actually also the recommendation of the CPT, and now we drafted an amendment to the legislation to abolish it by law. Also, as during the last visit of CPT to Azerbaijan, during the meeting, I'm not exposing the report, but during the meeting at the ministry, members of the CPT who visited female prison and juvenile prison, they said that they had no single allegation. They didn't hear any single allegation about the torture facts in these two institutions. We also started, since using the IT, as I said, apart from the video conferencing, we started to use, and we changed the legislation to allow prisoners to use video meeting with their relatives for 15 minutes, and also providing 7 days vacations, depending on the behavior of the prisoner, of course. And when it comes to juveniles and females, we have a number of projects with the UNICEF, with a number of NGOs inside the prison regarding their vocational training and so on. Interesting point for me, as for instance, the person who is fond of football, many prisoners from, not many, there are only actually 26 juveniles in the juvenile prison at the moment. They go out to watch football games. We arranged even a game with the junior team of our best team, Karabakh, which qualified to the quarterfinals of the Europa League. So they had a game inside the prison with the junior team of this game, which was fun, which was very interesting, and I think they were honored to meet with these people. When it comes, they also have computer classes, language classes, but I believe this is a common practice. And as Madame Gaharmanova also mentioned, we have open doors practice in both of these prisons. When they can meet their relatives, their peers, they do some other activities together. And also, when it comes to females separately, I'd like to know that we are now working with the several entrepreneurs to provide, to ensure that these persons, when they are released, they can find proper jobs. So, for instance, with a number of cleaning companies, we have a certificate-based training on the cleaning, and some of females who were released already, they are now working at several hotels doing cleaning, for instance. Chefs also from several top restaurants in Azerbaijan, in Baku, basically in the capital, they do training on cooking for many people, and then also some of them are later on recruited after their release. Females even have their own music band, which was widely broadcasted on TV as well. When it comes to the training activities, of course, it's very important to do the training, including the Istanbul Protocol. As you mentioned, Madam Rako, yes, indeed, training on the Istanbul Protocol, especially for members of our medical service, is mandatory. Within this period, since 2020, we had 10 trainings for about 120 medical staff, including over 500 other professionals, like lawyers, and 122 judges and 231 candidates. The difference between training for judges and the candidates is that training for judges is voluntary, because we can't force a judge to go for a training. When it comes to judicial candidates, it's included in their curricula. So basically, I believe that's it when it comes to the questions of raised by Madam Rako. When it comes to several legislative issues raised by Mr. Buchwald, I would like to note that indeed, as Mr. Buchwald suspected, when it comes to Article 40 of the Criminal Code, it is indeed a translation problem. And the word obviously is not really reflecting the wording of the article. So basically, it should sound like, let me quote the translation. The person who committed a deliberate crime by execution of illegal order or instruction, which he knew it is illegal or he should have known it is illegal, shall carry out the criminal responsibility in accordance with the general grounds. So it's not obviously, no one is deciding on this issue whether it's legitimate or not. When it comes to Article 293, regarding the definition of torture, I would like to know that in the first paragraph, the article speaks about the harm not reaching the torture threshold. But when it comes to the sanction, it's, well, one might say that it's a subjective view that the sanction is not that high, but if you look into the other criminal sanctions in the criminal code, like, for instance, murder by negligence or murder in the state of affect, it's almost the same sanction. However, when it comes to torture, in the paragraph 2, the sanction reaches maximum of 8 years, which according to our legislation, based on the severity level, comes under the understanding of the serious crime. For us, when the sanction is over 7 or over 7 years, it means that the crime is serious. And therefore, it should be considered by a serious crimes court and not even an ordinary court. When it comes to the Article 75 on the lapse of time, well, indeed, it does apply to the torture article. However, if you look into this paragraph 3 of this article, it says that if person is hiding from the investigation, the time flow shall be suspended. So basically, in practice, if the person is hiding, is fugitive or running away, it's not counted. So 12 years period for this particular type of crime, it's not applicable in this particular case. Regarding the extradition, I believe I am reaching the time limit, but I still have some information regarding extradition and diplomatic assurances, so it's up to you, Chair, to decide whether should I continue or I can come back after the break.
Thank you, Mr. Abilev, for your detailed information. Of course, we have some issues which we know that you wanted to share with the audience, but we are in the hands of our Chair to decide whether we have a couple of minutes that you will finish your statement, or so you can finish on diplomatic assurance. Okay. Thank you.
Thank you very much. Well, when it comes to, sorry taking your break time, but yet, I mean, I'd like to raise a couple of issues regarding the diplomatic assurances. Indeed, not only in expulsion cases, but also in extradition cases dealt by the court in Azerbaijan, we do use diplomatic assurances. And basically, that goes both sides. So, which means we require, when we see that there's might be a risk that the surrender of person or extradition of a person can be resulted in torture, we do require diplomatic assurances. And we do sometimes ask even for post-extradition monitoring by our consular services. Or we ask from our partners the follow-up information after the surrender. For instance, just for your information, within this period of time, since 2020, we rejected extradition in 2 cases to Iran because of human rights situation in Iran regarding these particular persons. One actually was of Azerbaijani origin. Sorry, he was Iranian national, but original Azerbaijani. And one case was regarding the rejection of his extradition to Oman of a Pakistani national. When it comes to us also, we, in one case of the extradition to Thailand, of a person who was suspected in the human trafficking, national of Uzbekistan, we required the assurances. Only after that we surrendered this person, but yet we asked later on our Thai partners to provide the follow-up information of this person. And the same case we had with India, when we extradited a person to India, according to the bilateral treaty, we not only asked for a general, human rights and torture assurances, but also there was a risk that a person could be sentenced to a death penalty because that was a murder case. So we asked specific guarantees that death penalty in this particular case would not be executed as well. So basically, that's what we do while we consider extradition requests. Also, just one more minute, we had a couple of fact-finding missions coming from different countries during the extradition proceedings, namely Germany and UK, who came to see our pre-trial detention facilities and the prisons, so that to make sure that the extradition of this particular person, the fugitive, would not violate his or her human rights. In both cases, the defense, they didn't get anything, so the reports were positive. And after that, we got extradition from both of the states. But it's not a common practice as far as I know, and not all states do allow this kind of fact-finding missions to come and see their prison facilities. However, taking into account the interests of Azerbaijan, first, on one hand, fighting